Hey, this is Jim Santel. I am the host of Morning Cannolis. Every single Saturday morning from 9 a.m. to 11 a.m., we talk about the major stories in law, in government, and the aspiration for justice in America. Delighted to have you join, call in, and be a part of our discussion right here on the networks of Civic Media.
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning and welcome to the final broadcast of 2022 of our weekend review, our Saturday morning review of the important stories in law, in government, and the aspiration for justice in America. Thank you so much for joining me, not only this morning, but on so many other Saturday mornings since June of this year. This is our 28th broadcast. Yes, we're going to be continuing into 2023, perhaps even beyond that, to talk with you every Saturday morning, virtually every Saturday morning, about these major stories that affect our lives on the world basis, on the statewide basis, and even locally. Thank you again for joining me here at the studios of WAUK Radio, the Shaw in Waukesha. We're at 540 AM, 101 FM, and as always, this morning on Morning Cannolis, I'm joined by my wonderful, professional, ever-attentive producer, Calvin, and he and I are going to be taking your phone calls this morning, as we do in every 2-hour segment throughout the year at 844-967-2789. Call in, as always, with your always excellent comments, your questions, your thoughts, your perspectives, provided to give you some sense of responses to those, but also some ways about thinking about the world around us. That the civics mission of our program, our broadcasts every Saturday morning here on Morning Cannolis. We have, throughout the past 6 months, been attentive to those major stories, and this morning is no exception. As always, we have an aggressive but achievable syllabus, an academic approach to what we're going to be talking about today. Many, many stories that have populated the news locally, statewide, nationally, internationally, just in the past couple of weeks since we have been on the air. Took a brief hiatus over the Christmas weekend holiday. Back on the air this morning to talk about many of those issues. And I'm going to change our format just a little bit. I promised that today, like other programs at this time of the year, that we'd be doing a year-end retrospective. I decided in the past 10 days or so that given the significance of some major issues out there, that we would do a very intensive review of the last 10 days, 15 days or so here in America and around our 50 states and territories, talking about those issues. We'll hold off on the year-end retrospective, some of those things that we should be thinking about, not only in connection with what happened in 2022, but also in 2023. We'll be doing that in January, talking not only about the past, but also about how that will animate the major issues going forward. But many, many, many major issues in law, in government, and in the promotion of the rule of law that are important to understand and know. So we're going to talk about those this morning in our first hour. Those include everything from the decision by the United States Supreme Court on this major asylum issue, the sentencing of some criminal defendants for the attempted kidnapping of the Michigan governor there, the arrest of a suspect in the horrific murders of those Iowa University students in early November, some pardons issued by the president just yesterday or so, and finally, we're going to talk in this first hour, time permitting, about the returns just being released by the House of Representatives, the Ways and Means Committee, and the Joint Committee on Taxation of the former president's tax returns, about 6 years or so of those. That's going to animate the first hour of our time together. We'll see if we can get through all of that in the next 60 minutes or so. And then in the second hour, because of the major information coming out of the January 6th final hearing of December 19th, and then also the major report issued just about a week or so ago, going to spend most of the hour parsing through that, getting some sense of what the major issues are there, necessarily not being able to do a deep dive into everything that is there in an over 825-page report, but doing some of the major highlights of that. That will be our second hour. Again, as to all of this, Calvin and I encourage your calls, your questions, your comments at 844-967-2789. Thank you again for joining us. Let us jump right into some of those major issues that have attracted the headlines in our newspapers, on our news feeds for the past 14 days or so. We have spent a lot of time here on this broadcast in the past 6 months talking about the Supreme Court. That will not change in 2023, not only as we're going to chat again about some of the new cases the Supreme Court has taken on, but also probably in May and certainly in June, reviewing the major decisions in probably 10, 14, 15 different cases pending right now before the United States Supreme Court. Everything from environment to privacy rights, to religion, to all sorts of things related to healthcare and education, very significant issues. One of those has to do, of course, with immigration. There is a major case pending, as we have spoken before in this broadcast, involving the authority of the Secretary of Homeland Security, under statutory authority given to him by the United States Congress to act, to administer, to put into effect, to execute our immigration policies in this nation, the authority of him to act in a way that permits him to prioritize, focus on those individuals in our nation who are truly threats to our safety and security. What happened this past year, as you well know, is that the Secretary of Homeland Security, Alejandro Mayorkas, issued an order directing the Border Patrol agents and immigration authorities throughout the country to prioritize those who are committing crimes and focusing on investigations of them, deportations of them, proceedings of them, so that we are focusing on those people who pose the greatest threats to our safety and security. A challenge to that administrative, that employment, that oversight decision by the Secretary now before the Supreme Court. It's going to tell us whether or not the Secretary of Homeland Security has that authority under the statute to do exactly that kind of thing. In the midst of that, while that is pending, just this past week, a major story also coming out of the immigration docket before the United States Supreme Court, having to do with what you probably know colloquially as Title 42. This, of course, is the Trump administration policy enacted during the height of COVID, the pandemic itself, that allowed for the speedy expulsion of undocumented migrants coming here, seeking asylum in our nation, and reversing, if you will, the traditional practice for dealing with their applications. That practice has always been that even though there are applications for asylum pending, the United States government, the immigration authorities, would permit those people to come into our nation conditionally while their applications are being reviewed. The policy, that practice, was changed again on a limited basis, a time-limited basis during COVID, during the Trump administration, based upon the notion that the movement of individuals across our borders might tend to exacerbate the problems that we're facing with the pandemic. And so this particular Title 42 permitted immigration authorities to not only expel but also keep those asylum seekers on the other side of the border while this health emergency of our nation continued. Biden administration comes into power and says, you know, as the pandemic begins to wane a bit, do not want to indicate at all that it is over. We know that there continue to be some very, very serious concerns out there, both for individuals, groups of people, communities generally. Do not mean to limit or in any way suggest that our problems are not over, but beginning to say that this particular Title 42, this particular regulation, probably has now outlived its usefulness, in that the rate of pandemic concern is now dissipating somewhat. And so propose that old, still existing, but previously imposed regulation of the Trump administration be rescinded and be removed. Number of different states, 19 different states, come forward into federal court, and they say we'd like to object to that. We'd like to keep that in place on the basis, they say, that the pandemic is still a significant reason for continuing Title 42, And lo and behold, just this past week, the Supreme Court decided that it would hear that case, that would determine whether or not the lower court's decision, an appeals court decision that said, yes, Biden administration, you can rescind that order now. The Supreme Court has said, we're going to take a look at that. And while we're taking a look at that, Title 42 continues to be in place. And what that means, of course, is that the Trump-era regulation continues to affect this suspension of our long-standing process with respect to asylum seekers in this country. In an unsigned decision just this past week, the High Court scheduled an oral argument for February on this, and then likely, once again, like all these other cases that we have talked about on this broadcast, likely going to decide this case sometime in May, perhaps June, maybe even July, but whether or not, again, this COVID-era regulation should remain in effect or should it go away. Interestingly, there are 4 members of the Supreme Court who object to the court not only hearing this, but potentially overturning the lower court, which would have permitted the rescission of that policy to go ahead. And not surprisingly, 3 of those Supreme Court justices, they're Ketanji Brown Jackson. That includes also Elena Kagan, Sonia Sotomayor, the 3 so-called liberal or on that side of the fence Supreme Court justices, joined, very interestingly, by Associate Justice Neil Gorsuch. And along with Ketanji Brown Jackson, writes a fairly scathing opinion about what the Supreme Court has done here. Justice Ketanji Brown Jackson, specifically Justice Neil Gorsuch, say this: courts should not be in the business of perpetuating administrative edicts designed for one emergency only. He's talking plainly about the pandemic, because elected officials, talking about the Congress, maybe state officials as well, have failed to address a different emergency. And here's the all-important language coming out from Justice Gorsuch and at least 3 of his colleagues, again, not in the majority. He says, we are a court of law, not policymakers of last resort. And so a failure, if you will, of those people who wanted Title 42 to be rescinded, a setback for the administration in terms of its enforcement of immigration policy, a return to the policies and practices that existed prior to the Trump administration and prior to COVID. That not happening because the Supreme Court once again suspended that, said keep it all in place while we take a look at that. Major news this past week coming out of our United States Supreme Court. Again, we'll talk about that more down the road as well. We're also going to talk about other major issues here right after the break here on Morning Cannolis. Stay with us for all of that. And again, call in with your questions, your comments, your thoughts, and your perspectives. We are back. Thank you once again for joining me here on our weekend review of law stories, of justice stories, of rule of law stories, of government stories here on the radio networks of civic media throughout the state of Wisconsin, 540 AM, 101 FM, as always, taking your phone calls and comments and thoughts and responses at 844-967-2789, continuing in review of what has turned out to be a very chock full of news couple of weeks, and spending some time this morning in our first hour talking about some of these stories, many of which were in the headlines, some of which were not. Let's talk about another one of those major stories. We have chatted in the past on this broadcast about this horrific matter coming out of the state of Michigan. About 14 different individuals had planned to kidnap the then governor, continuing governor, recently reelected to the gubernatorial spot there. Her name is Gretchen Whitmer, the governor of the state of Michigan. About 14 individuals had plotted to kidnap her, presumably to kill her, because they were objecting to not only her policies on COVID, but also her positions on reasonable and rational gun control. Michigan, like many other states in the union, affected dramatically by gun violence in our nation. And so this group of 14 people, including 2 individuals named Barry Croft, the leader of this 14-member group, and Adam Fox, probably the second in command, a part of this group that organized this plot to kidnap her, to take her, And as, again, a way not only of stopping her from doing what she was doing, but also, as we're going to find here in just a moment or so, describing to other potential leaders of our nation what could happen to them if indeed they did not agree with this right-wing, completely anti-American set of people. Well, we know well that there was also a connection to Wisconsin in this matter, because virtually all of these people had come to a location not too far from where we are right here at the studios of WAUK in kind of south central Wisconsin to train, to plan for this event involving the kidnapping of the governor. During the course of the sentencings this past week, the assistant United States attorney in federal court in Western Michigan, where this case was charged, said the only remaining step in this kidnapping plot was for the governor to appear at her cottage. Went on to say her abduction was only meant to be the beginning of the reign of terror, including calling for riots, torching government officials in their sleep, and setting off a domino effect of violence across the country. Horrific plans in place by this group to undermine not only the authority, the physical security of the governor, but also to throw American justice into disarray as well. As I indicated, a very, very compelling presentation by the government. This past week, two of these major ringleaders, Barry Croft, sentenced to 19 years imprisonment for his involvement in that plot. Adam Fox sentenced to 16 years imprisonment for his involvement in that. You might say, well, gee, how did the government find out about this? Indeed, the FBI had inside this group an internal informant who not only was able to monitor what was going on, but stop this before it happened. And so did not, in fact, go forward. When the plot itself was extinguished, the governor blamed then President Donald Trump, saying that he had given, quote, comfort to those who spread fear and hatred and division. And about 19 months after leaving office, Trump said of the kidnapping, the plan was a fake deal. Well, it wasn't a fake deal, Mr. Former President. The reality is that these people were serious. They had plainly committed overt acts in furtherance of it. They were stopped by some very good and effective law enforcement, and now virtually all of them being sentenced in state and federal court for their involvement in this kind of activity. As always, we've got callers calling in. Dana from La Crosse this morning, glad to have you with us. Your comments or questions already here on Morning Cannolis.
Good morning, Mr. Santel. It's really a pleasure to speak with you.
Glad to be with us, Dana.
Yeah, you got a great show, and I really like the way you present your discussion. Very nonpartisan, but you spell it out so well for the everyday citizen, everyday listener. And
Appreciate
so thank you so much for this great show. Question about first the Title 42.
Yes.
So the Republicans are in these various states. They're claiming their reasoning want to keep it alive is their concerns of COVID and bringing that over the border. Yet, preceding all of this for 2 years now, they've all been denying it even exists, and it's even a worry. So does that hypocrisy get presented in court? What do the Supreme Court justices do in consideration of that hypocrisy? And
Sure.
why doesn't it have a larger effect on that?
Right.
And I do have another question that you brought up about Governor Whitmer, but go ahead.
Sure. So to respond to that, the answer once again, Dana, is yes, yes, and yes. Not only in the court of public opinion, your identification of the hypocrisy here, right, is significant. That on the one hand, major leaders, not exclusively in Republican jurisdictions, but saying that COVID is not real. Now we're using that as a reason to continue this operation. Probably the real reason for this is we're opposed to people who are not United States citizens, who are not legally here from coming into our country, using this as a reason for stopping that immigration. So the hypocrisy is there. The question whether or not that is presented to the court, absolutely. And if you listen to some of the oral arguments on these cases, you will find on a regular basis that the courts will ask those practical, real-world questions about what's really going on here, what's what's happening here. How do you justify, how do you reconcile one with the other? Lawyers will write about this in their briefs. They will talk about it to the Supreme Court, and the Supreme Court does, in fact, wrestle with it, even as they're addressing the specific legal, statutory issues here, the regulatory issues, the administrative processes, all of those kinds of things, very much a part of the Supreme Court's analysis and its considerations, certainly. Justices live in the real world, too. We're going to chat. Dana, stay with me on just for a moment, and I'll take your question about the Governor Whitmer situation right after the break here on Morning Cannolis, and we'll talk further about that and other issues facing our nation this morning. We are back in our weekly broadcast of news, of law, of government, and justice in America. And right before the break, I was chatting with Dana from La Crosse. Had a great question about what's going on with respect to Title 42. Hopefully answered that. And Dana, you had another question about this matter, this horrific matter involving the attempt to kidnap the Michigan governor and people being brought to justice now in the federal courts, also in the state courts of Michigan for that heinous behavior. Dana, why don't you go ahead with your next question?
All right. Thank you, Jim. Thanks for having me back for my second question. You exercised my brain, let me just say.
Good.
So regarding the punishments that are being handed down for these plotters of Gretchen Whitmer, I'm noticing some of them are rather high, 16 years, 17 years, with potential for life sentences.
Right.
With that in mind, with these sentences getting more severe, you know, we've noticed that a lot of the sentences for the insurrectionists, you know, they've been rather light in a lot of people's opinions. Do you think that with these more severe sentences being handed down for these plotters, that foreshadows maybe more severe penalties coming for the actual plotters and planners of the insurrection and, the higher ups and, show some true accountability.
Right.
I'll take my answer off the air. I just want to say again, Happy New Year, and let's hope justice prevails in 23.
Absolutely, Dana. And thanks for those best wishes to me and to Calvin and to all of our listeners out there about a more safe and secure 2023 and beyond. As to that particular question, yes, so a couple of perspectives on that. These are not insignificant sentences. The federal system, judges impose sentences based upon something called the sentencing guidelines, gives them some ranges of sentences to impose. Undeniably, some of the less culpable conspirators in this group of 14 in the state and federal sentences, a little bit less time imprisonment. But these are, as Dana just said, they're significant sentences, sending an important message about what we've talked about a lot on this broadcast, which is deterrence, right? Specific deterrence as to these individuals and people like them who might think that they would be encouraged by this kind of behavior. The answer is no. You will not only be found out, you'll be prosecuted, and you'll be sent to jail for significant periods of time. That's specific deterrence. And then general deterrence, which is if there are other people out there, whether they're thinking about a specific plot like this absolutely offensive, horrific plot hatched by these folks or others. And Dana talked about the plot to overthrow our government as another one of those. The purpose of those prosecutions also deterrent. As to the specific people who were there, something in excess of 900 people already prosecuted for their on-site involvement on January 6th. That's not insignificant. As Dana said, some of those getting as something as simple as probation, home arrest, others getting months and years in prison. Some of them at higher levels, including members who were organizing and supervising, getting more than 10 years, 12 years, 13, 14, 15 years in jail. And those are still the exception, not the rule, but plainly heading in that direction, even as we know that the trials of people like the Oath Keepers and the Proud Boys, those are still continuing this month, next month into February. I do, responding, Dana, to your specific question, anticipate that this not only trend, but this sending of the messages by judges, which has been going on for years, candidly, about what happens if you engage in this kind of conduct, those kinds of messages, the deterrent messages being sent, that can and should continue, not only for those people who might engage in violence, whether it is in Michigan and Wisconsin and other places around our nation, but for those, most importantly, I think this is the core of your question, Dana, who would be responsible for organizing, supervising. To that point, Dana, we're going to be spending much of our second hour this morning talking about the January 6th report and what it shows, what it has revealed about those higher level decision makers, those leaders, if you will, I'll say it's with a small L, who might have brought, as Liz Cheney said, lit the match, brought people to the United States Capitol, Washington, D.C., and prompted what happened on January 6th, perhaps also including our former president. So great message there about deterrence. Yes, it should continue. Should be a message not only to those individuals, but to others out there who might think of doing the same kind of thing. Let's talk about another very, very serious matter in our nation's criminal prosecution history recently. We all recall well, still horrified by the November 13th attack of students at the University of Idaho. Their names are Ethan Chapin, Madison Morgan, Zaina Nordal, Kaylee Calves, and others who were murdered, again, on the campus of the University of Idaho back in November. All of them horrifically killed 4 University of Idaho students at that time. And the question for a long period of time is, what is law enforcement doing to follow up on this? State, local, plainly federal law enforcement as well, trying to find out what happened here. And some increasing concern about whether or not the person who is responsible for the killings of those 4 University of Idaho students was in fact going to be brought to justice. In fact, just yesterday, a Pennsylvania judge in Monroe County, which is north of Allentown in Pennsylvania, had before him an individual named Brian Christopher Kohberger, Kohberger. He's 28 years old. He was booked into custody on an arrest warrant that did, in fact, come out of Moscow, Idaho, which was the place where the arrest warrant was issued by the prosecutor there. It charged Kohberger with first-degree murder, being held at that Monroe County Correctional Facility, according to all the reports coming out of that proceeding. The authorities plainly indicating that they believe that they have the individual who is responsible for that. The Moscow police chief, a fellow named James Fry, said just yesterday that we have an individual in custody who committed these horrible crimes, and I do believe our community is safe. But importantly, again, this notion of law enforcement protecting us all, but we still need to be vigilant, the police chief said. All of this perhaps bringing closer to justice the person who committed these horrific crimes. I will say, as I did for 30 years, that an individual charged with an offense conduct of this kind, of any kind, is presumed innocent until proven guilty. That attaches by virtue of our Constitution, our federal Constitution, our state Constitution, and that presumption of innocence remains with Mr. Kohberger to the time, and we certainly anticipate that a court or a jury will in fact do this, but until that time that there is a criminal judgment of guilty imposed upon him in our system, that remains with him. Even so, bringing to an end this initial portion of the investigation, bringing Kohberger into custody, the judge ordering that he be extradited to Idaho next month, which is probably in the next few days, if not weeks. Court records likewise confirming that. And so we have someone now finally in custody. Plainly, well, the question is, what's going to happen next? Well, he's brought back to Idaho to face those state charges. They're not federal charges. State charges there, these 4 counts of first-degree murder with respect to the murders of these 4 University of Idaho students back in November. Plainly, a lot of pretrial proceedings. He will have an arraignment in front of the state court judge who will set time for hearings and motions and then eventually set a trial. And again, Mr. Kohberger, like every other criminal defendant, has the right to defend himself in a trial. If he chooses to do that, he could also eventually enter into a plea agreement, perhaps with the government. Difficult to envision that Mr. Kohberger, assuming the evidence is credible, that is material, and the government can, in fact, and probably will be able to show beyond a reasonable doubt in our criminal system, that's the standard, to a jury by a unanimous verdict, to a court, likewise, beyond a reasonable doubt, that he is, in fact, guilty of those offense conduct behaviors. Very likely that Mr. Kohberger will spend the rest of his life in prison, in Idaho prison, for committing those horrific, violent murders. But again, the presumption of innocence remains with him until that is done. We will certainly continue to watch that story as it proceeds forward. Let's go in the opposite direction then. Another big piece of news coming out again just yesterday from the annals, from the books of law and justice and government in America. And this has to do with the president's pardon authority. We have spent a fair amount of time on this very broadcast talking about this delivery of authority by our United States Constitution, by those folks who wrote the Constitution, people like James Madison, George Mason, many, many others, who established a system of checks and balances. Again, we're going to spend a lot of time talking about the implications of those checks and balances in our second hour as we get more centrally to January 6th. Checks and balances inside our Constitution. One of the very few, perhaps even the exclusive authority vested in one of the branches of government is the power to commute sentences, to issue pardons, and it's granted to our chief executive in the federal system. The language in the Constitution, Article 2 of the Constitution, which is all about the executive branch, Article 1 being the legislative branch, Article 3 being the judicial branch, Article 2 establishing who the president is, what the authorities of that person are under our Constitution. Among those says pardons can be issued by our president. And so just this past week, the President of the United States of America, has every other president preceding Joseph Biden, issued pardons in 6 different cases. I'm going to spend a little bit of time this morning talking about those because it stands in marked contrast to some of the other pardons that were issued by the former President Donald Trump during his term. We've talked a lot about this. There is a process for pardons in America. It goes through the Justice Department. There's an Office of a Pardon Attorney. If indeed, typically, you have served your sentence, if you have somehow done something in your life that justifies this special commutation, special consideration to basically wipe clean, if you will, the records of these convictions of various things, because you have done things in your life that show that you not only acknowledge your guilt, which is an important part of this, but also understand the importance of adding to the community. Under those circumstances, the Supreme Justice of our executive branch, which is the president, in the execution of justice, can issue a pardon. And again, typically goes through a review process at the United States Department of Justice, coming up through the Office of Pardon Attorney. And again, Joe Biden just yesterday announced pardons in 6 different cases, a lot of them having to do with these kinds of things where justice now requires, in his view, and I think as you listen to some of these stories, the views of many people, the acknowledgement that these people have, in fact, paid their debts to society, as we often say, and now warrant these kinds of commutations. Beverly Ann Ibn Tamas, she's 80 years old. At the age of 33, she was convicted of killing her husband. You might think, gosh, that sounds just horrific. She testified, however, that her husband beat her, verbally abused her, and threatened her. She told jurors she shot him moments after he had assaulted her while she was pregnant. A judge at the time had refused to allow some expert testimony on battered women's syndrome, which is a psychological condition, as we now know, that can develop among victims of domestic violence. She went on to serve 5 years of incarceration, credit for some time served. Appeal was among the first that arranged this notion of the battered women's syndrome and her case is now being studied by academics. She was one of those 6 people, was pardoned by the president, again acknowledging that her crime, that she also acknowledged, killing her husband, nonetheless mitigated by the fact that she herself was a victim of domestic violence. That's the kind of person who I would offer to you. Obviously, the president, in his review of this, the Justice Department also agrees with the notion she is the kind of person who warrants this kind of special constitutional gift, if you will. It is regarded by the Supreme Court as just that. The Supreme Court has talked about it as an expression of grace by the executive. Charles Brins Jackson, 77 years old. He's from South Carolina. He had pleaded guilty to possession and sale of spirits without tax stamps when he was 18, involved in a single illegal whiskey transaction. He tried to enlist in the Marines, was rejected because of the conviction. The president also pardoning him just yesterday. Again, a situation where the crime plainly, while it existed, acknowledged, nonetheless appropriate for a pardon. After the break, I'm going to talk about a few more of those and then finish up with another significant piece of news from the annals of our news headlines this past week. Stay with me here on Morning Cannolis as we talk about those and other important issues. We are back here on Morning Cannolis. We're talking this morning, as we do virtually every Saturday morning, about major news stories, trying to make some sense of them in the areas of law and justice and the administration of justice in America. Right before the break, I was talking about this all-important authority given to our United States presidents under Article 2 of the United States Constitution, and that is to pardon people. The authority, as I indicated, one of the very few in our Constitution that does not have a check and a balance on it. You can't go into court and challenge these. The Congress does not have the capacity to override a pardon issued by a president. It is pretty much a complete authority by the president to do what he, or perhaps one day she, wants to do with respect to this incredible authority. Again, we say this because it underscores the importance of selecting presidents who have a sensibility to these kinds of things. What is the rule of law all about? What is justice about? And what are equities about? Being fairness and being fair, and exhibiting fairness in the administration of justice. Well, I would offer that President Biden just yesterday, in the pardons that he most recently accomplished, has been doing just that. Let me talk about a couple more of those to give you some sense of what a pardon authority is properly about, how it's properly exercised. This fellow, his name is Gary Parks Davis, 66. He's from Arizona. When he was 22, he admitted using a telephone for a cocaine transaction. Serious matter, absolutely. Served a 6-month sentence on nights and weekends. County jail, completed probation in 1981. After the offense, Davis earned a college degree, working steadily throughout his life, owns a landscape business, managing construction projects, volunteered at Children's High School in his community, the kind of person who has turned his life around. And again, not in any way minimizing the significance of the conviction, the criminal behavior in which he did in fact engage, but recognized now by our chief executive, this is a fellow who should be pardoned in the interests of justice. What about a fellow named Edward Lincoln Dakota of Dublin, California? He pleaded guilty also at the age of 23 to being involved in a marijuana trafficking conspiracy. Once again, a serious matter. Released from prison in December of 2000 after serving a couple of years in prison. Before the offense, Dakota had served honorably in the United States Army. The Army reserved numerous awards in service to our nation. Edward Dakota yesterday pardoned by our president for that conduct. Again, admitting the guilt, admitting to doing the offense conduct, but putting his life together in a way that justifies this expression of grace, as the Supreme Court has called it. And finally, let's talk about the sixth among them. His name is Vicente Ray Flores. He's 37 years old as a 19-year-old. And again, notice the differences in ages here, that these are offenses committed traditionally, at least in this group, by younger people. Flores had consumed ecstasy and alcohol while serving in the Air Force. He pled guilty to a special court-martial, acknowledging once again the seriousness of his conduct, sentenced to 4 months of confinement, a loss of about $2,800 in pay, reduction in rank. Participate in a 6-month rehabilitation program that gives select enlisted offenders a chance to return to active duty after therapy and the education that they would receive in that program. His reduction in rank was amended. He remains on active duty. He earns medals, other awards for his service, again, turning his life around, again, serving our nation in a way that yesterday justified Joe Biden's giving him a presidential pardon under Article 2 of the Constitution. Why do I raise all that? Well, it's news. Certainly, it's significant in the administration of justice in our nation. It's a constitutional matter, as I've once again instructed and talked about this morning. But beyond that, look at how it's all of these pardons and previous pardons also issued by this president stand in contrast to the kinds of pardons that the former president, Donald Trump, issued. Among them, for example, to a Roger Stone for federal involvement in this attempt to defraud people to build the southwest border wall. Charges now brought by the state system. Also, a imposition of a pardon for Paul Manafort, his prior campaign manager, for all of the crimes that he committed, the subject of an awful lot of review and analysis and presentation in federal courts by the Justice Department. And again, even as late as this past week, we've got talk of the extent to which in the last days of the Trump administration, talk about blanket pardons for anybody who might be involved in January 6th. Blanket pardons. And again, the notion behind a pardon is that you confess, you acknowledge that you have committed crimes. That's a key portion of this, and that therefore you are somehow in some way entitled to this special consideration, commutation of sentence. We know from just this past couple of days and weeks that there was an awful lot of discussion in the waiting days of the Trump administration about whether or not the president would not only perhaps pardon himself, but others around him, his own family members, senior aides, talking actively, as these transcripts have now shown, coming out of the January 6th committee analysis, talking about whether or not there should be a request of the president to issue blanket pardons. We know the president did, in fact, issue some pardons. We talked about those on previous broadcasts. An important thing to keep in mind as we think about the exercise of this all-important constitutional authority by this president, by past presidents, and by future presidents as well. And finally, in our last moments of this segment, this first hour of Morning Cannolis, and going into the second hour, let's return to the former president. Some very big news, again, issuing just in the past couple of days, the past week or so, including even as we speak, the release of about 6 years of his federal tax returns. We know that the Department of Justice is looking at the former president in connection with many of the January 6th violations. This has to do with matters that are somewhat related to that, arguably, but go to a years-long attempt, about 3.5 years, by the House Ways and Means Committee to try to obtain the federal tax returns of the then sitting president. An effort pursued by the House Ways and Means Committee, also by the Joint Committee on Taxation in our federal courts, to try to compel the Department of Treasury to release these to the United States Congress. You know well that it has been the tradition of every presidential candidate, and yes, every president annually, to release their tax returns. Why? Just so Americans know what their president is all about financially, economically, what kinds of businesses he, one day she, is involved in. Those kinds of things important for transparency in America. That going on, finally resulting by the United States Supreme Court saying, yes, indeed, the House Ways and Means Committee does, in fact, have the right under a federal statute to get these tax returns by the United States Department of the Treasury. Released in the past several days, the past week or so, a report issued, and then, just in recent days, the tax returns themselves being reviewed as we are on the air this morning, yesterday, today, tomorrow, to analyze exactly what those show. In the first moments of our next hour, we're going to talk more about what those tax returns show, what they don't show, and what it means, what this means in terms of the rule of law in America. Stay with us for that second hour of our examination of law, government, and the aspiration for justice here in the United States of America.
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning and welcome to our second hour here. We're live at the studios of WAUK Radio in downtown Waukesha. It's the Shaw 540 AM 101 FM. And by that I mean me and my producer, Calvin. And along with Calvin, I'm taking your phone calls at 844-967-2789. This plainly the last broadcast of Morning Cannolis of 2022. But back again next Saturday, continuing beyond next Saturday, always every Saturday morning, talking about law, talking about the big stories in government and the aspiration for justice in America. As we were going into break over the top of the hour this morning on Saturday, December 31st, we were chatting about this other major news story having to do with the return of major news coming out of Washington once again, the release by the Department of Treasury of the former president's tax returns for about 6 different years, immediately preceding his presidency, beginning in 2015, and including 2020. That is the year in which, of course, he left the presidency. Those requests being made by the House Ways and Means Committee, also by the Joint Committee on Taxation. The release on Friday morning, just yesterday, of thousands of pages of tax documents, including individual returns by Mr. Trump and also his wife, Melania, business returns for several of the hundreds of companies that make up his real estate and other business holdings, really a sprawling business organization, right now the subject of an awful lot of review and analysis. But we do know, based upon some early reporting coming out of the House Ways and Means Committee, and also some initial review of those returns and those many documents released, we do know some things about the former president's taxes, and some things, not complete things, some things about his business holdings. Let's do one of the major findings that was the subject of the House Committee report that described the failure of the United States Department of Treasury in the first 2 years of the Trump presidency to do what the Treasury Department has done for every other term of a president in recent contemporary history, and that is conduct an audit. You may recall well that during the course of the campaign, 2015, 2016, the now former president maintained that he could not release his tax returns because they were under audit. That, as a pure matter of law and process and procedure, is wrong. That's false. Any one of us can, at any time, release publicly. We can post them on social media, if you like, our own tax returns. What cannot happen is the IRS does not have the authority to release those on behalf of government absent a specific need. So, for example, inside the Department of Justice, if there is a reason to have those tax returns for the pursuit of a legitimate, a credible, a justified criminal investigation, there is a process for getting those tax returns, again, not released in the public, but in pursuit of a criminal investigation. Likewise, the United States Congress, pursuant to established statutory authority, can in fact get those tax returns, not only as a matter of its oversight authority, one of the significant things that the United States Congress, through its committee, does, but also determining whether there should be changes in the law with respect to things that may be revealed in those tax returns. And again, every president until President Trump has disclosed voluntarily his tax returns. Joe Biden, in the first years of his term, has done the same thing so that we can know what our president is all about when it comes to finances and business and economics. This past week, once again, we're not only getting this report, but also these thousands of pages of tax materials. The significant point coming out of the top of this report is for the first couple of years of the Trump administration, for reasons not yet known, the United States Department of Treasury did not, in fact, conduct its internal, non-public audit of the president's taxes as it has done and continues to do now for President Biden and presidents preceding Trump as well. We don't know about that, but certainly that's the kind of thing that a House Ways and Means Committee will be taking a look at. Certainly the kind of thing that even the present Secretary of Treasury, Janet Yellen, should be looking at, trying to determine whether or not there was a reason for this. Why did that happen? Was there a suspension? What was the reason for the suspension of that regular policy for 2 years at the start of the Trump administration? That a major big takeaway from the release of these tax returns, something we'll hear more about down the road. More significant, we know that from the release of these tax returns, lots of information about what the president did and did not pay. From the top line details from these returns, we know that Donald Trump paid about $1.1 million in federal income taxes during the first 3 years of his presidency, including a measly small $750 in federal taxes in 2017, which was his first year in office. He paid no tax whatsoever in 2020 as his income dwindled and his business losses mounted, again, reflecting that even on these top-line reviews of these thousands of documents, not the major, strong businessman that he would otherwise suggest that he would have wanted us to believe during his presidency, both before and after that. We know as well that during 2018, with about $24.3 million in income, Mr. Trump paid about $1 million in taxes. 2019, as he was nearing the end of his term of presidency, reported about $4.4 million in income and paid $133,445 in taxes. Again, we know that for a couple of years during this 6-year period of time, paid no tax whatsoever or paid about $750. We know as well, based upon some of the initial reviews of these documents and materials coming out of that in 2020, Mr. Trump paid nothing in charitable contributions. And why is that? Why is that significant? Well, you'll recall as well that during the course of the campaign that he promised to give every single one of the dollars of the $400,000 salary that the president makes on a regular annual basis. He said, I'm totally giving up my salary if I become president. And in the first 3 years in office, Mr. Trump did say that he donated his salary quarterly. But in 2020, his last full year in office, the documents that are now released to the House committee show that he reported $0 in charitable giving at all. And as 2020, as the pandemic recession descended a bit, Mr. Trump also reported heavy business losses and no federal tax liability as well. Some of this also coming out of the review is that Fred Trump, who is the president's father, still plays a major figure. He's still a major role, if you will, in the continuing financial status, the business activity of the now former president. In 2018, for example, after a decade in which the former president declared no taxable income as well, he reported a taxable income again, as I said, about $24 million, paid this $1 million in federal taxes, nearly the entire amount that he paid as president. And you say, well, gee, where does that come from? Well, the materials indicate, again, first blush, as we're reviewing all of this, that they appear to result from more than $14 million in gains from the sale of an investment his father had made in the 1970s. And that was a Brooklyn housing complex named Starrett City, which then became a part of Mr. Trump's inheritance. These new documents, again, coming out this past week, including just yesterday, showed that the effect of that inheritance in 2018 was actually more great than what one might otherwise have anticipated. Donald Trump reported about $25.7 million in gains from the sale of those business properties that he and his siblings inherited from his father and took through trusts, including the sale of this Starrett City enterprise that he inherited from his father. Those sales of properties created basically a loss for Donald Trump, our former president, dragging down his net proceeds for that period of time and somewhat reducing his tax liability as the itemization in some of those documents appears to show. So a lot of analysis coming out of that, more coming out of that certainly as the documents are further reviewed. Also, a lot of concern, a lot of suggestion about the nature of the charitable contributions the former president did, in fact, make. A lot of those in cash without documentary support. As you know, a part of that required by the IRS that you demonstrate not only the amount of money that you show at certain levels, but also that be demonstrated in the documents attached to a part of your regular tax returns. Questions about that, which leads me to my other comment, which is, what is next? What is next from coming from these tax returns? Undeniably, the Department of Treasury still looking at the nature of these tax returns. We don't know about exactly what Janet Yellen and the enforcement side of the Treasury Department may be examining in particular, but certainly given some of the questions about not only the charitable contributions, other things accomplished by virtue of these documents now being released at what they show, subject to an awful lot of analysis, could in fact, if indeed there were federal criminal tax violations, could be the result of this analysis ongoing right now, could be producing ultimately a civil tax prosecution, a criminal tax prosecution. We don't know. It's much too early to tell, but all of those things plainly not only now the subject of congressional review, again, in its oversight capacity, determining what, if anything, it should do in the future for future legislation, but also probably by the tax division of the Department of Justice, looking at all of this and determining whether or not there should be further enforcement action with respect to these past, perhaps even continuing present tax status of our former president. Again, the big news coming out of this, that the IRS during these initial years of the president's term didn't review this, didn't do an audit at all. And unmistakably, the House Ways and Means Committee, at least right now, in its final hours of existence, looking at that issue as well. Come back after the break as we talk more about issues in America, including January 6th and the report by the House Select Committee. We're talking about all of that right after this next break. And we are back here on Morning Cannolis. Thank you once again for joining me on this last day of the calendar year. We're talking now in the final segments of Morning Cannolis about the other major news issue coming out of Washington, D.C., and that is released by the House Select Committee on the January 6th insurrection, the release of its final findings through a major hearing that it conducted on December 19th. Just as the holidays were beginning here, and then the issuance in the days after that of a major executive summary, 150 pages summarizing in text its basic findings. And again, just this past week, an 850-page report that gives you in great detail, the results of its 18-month investigation into what happened on January 6th, what happened before January 6th, and what happened after January 6th. This omnibus review undertaken by the House Select Committee, now as of today, going out of business, as is every other committee of the 117th Congress. We know well that next week, the 118th Congress goes into session with the swearing in of all of the members of the House of Representatives and a third of the members of the United States Senate. Before the House Select Committee went out of business, or as it is going out of business in these waning hours of 2022, the House Committee once again issuing these major findings. We're going to spend the next three segments of Morning Cannolis talking about what was said during the course of that Monday, December 19th hearing, and then most importantly, the specific findings that are in that executive summary and in this major report that supports it. Also, at the same time, we have these continuing releases by the House Committee of virtually all of the transcripts of the more than 100 people who testified in front of the House Committee. We have seen bits and pieces of some of that testimony on the screen when the committee had its many hearings over the period of the past 18 months. We're now getting the transcripts of all of those transcripts also being released to not only the public for our consumption, but also to the United States Department of Justice, which, as we have talked about, we'll talk again at the end of our hour today about what happens next down the street at the United States Department of Justice, 9th and Constitution. What is the Department of Justice now doing? What are the next steps going on in the wake of the release of this report? What can we expect in 2023 from January 6th? Before we get there, some touchstones, some major headlines coming out of the hearing and big topic issues. Vice Chair Liz Cheney, who, as you know, was defeated in the primary to be the representative from the state of Wyoming. She said this. She said, every president in our history has defended this orderly transition of authority except one. And Liz Cheney, also, again, a major player, one of two Republicans on this bipartisan committee established by Nancy Pelosi to review all this. The executive summary that followed upon the presentation by the full committee said this: the evidence has led to an overriding and straightforward conclusion, implicit if not explicit, in what Liz Cheney and everyone else has said from the committee. Basically this: the central cause of January 6th, the committee said, was one man, former President Trump, whom many others followed. None of the events of January 6th would have happened without him. That, the key finding, the core focus of the committee hearing, the executive summary and the report, focusing first and foremost upon Donald Trump and saying that without him, without his being the linchpin, the core of all this, I'm going to talk in just a moment or so about the conspiratorial nature of what the committee described, his being at the core of that conspiracy. Also in that initial and final presentation by Liz Cheney and others on December 19th, making this finding that Trump's senior staff ultimately admitted that they lacked the evidence sufficient to change the election result, and they admitted that what they were attempting was unlawful, telling the president on repeated occasions that he had lost the election, that there was no there, that the so-called big lie was just that, a lie, gargantuan in dimension given his perpetuation of it, but none of that true. Again, that coming out of the initial executive summary. We also know from those initial presentations by the committee that we had a lot of specific accounts describing, if you will, the president's intent, his mindset, things being said to him by his senior staff. And we know from some of those initial releases that two names reappeared in that final committee hearing of the 19th. One of them, Hope Hicks, a senior advisor to the president. She confronted the president, according to the committee, about his place in history. And the president apparently replied to that, "Nobody will care about my legacy." This, again, the former president speaking. He said, if I lose, nobody will care about my legacy, so that won't matter. The only thing that matters, the president said, is winning. Very significant in terms of revealing his mindset and the reason for his being at the core of this attempt to overturn the election in 2020. Kellyanne Conway, again, a major senior advisor to the president. You know her well, too, from all of her media appearances, a major player in the West Wing throughout his presidency, told President Trump that January 6th was a terrible day, in her words, to which the president responded, nope, Kellyanne, people are upset. They are very, very upset. Again, all of that revealing something about what his senior staff was telling him. We're going to get back to some of that as well. A lot of that also reported in these major releases by the committee. I'm going to spend most of our time in the next segment or so talking about these major referrals that were made by the House committee to the United States Department of Justice, identifying what, in the committee's view, the president had done in terms of committing actual crimes in violation of the federal criminal code. We're going to talk about those right after the break. Those announced by Jamie Raskin, who is not only a major member of this committee, but also, as you recall well, the chair, the major presenter of one of the impeachments of the president for January 6th. Right after the break, we're going to chat more about what those are, the four major charges advanced to the Department of Justice, what they're about, the focus of those, and what they may mean down the road. Stay with us here on Morning Cannolis for that exposition of those charges and the refers made to the United States Department of Justice. We are back. We're talking this morning about these very significant findings, these reportings coming out of the House Select Committee on the Insurrection of January 6th, even as we go into a new Congress in just a few days. In its waking final moments of its existence, the House Committee on the Insurrection releasing this major report, 845 pages, among other things, finding just this. It says, in an effort to overturn the 2020 election and the results in key states, including right here in Wisconsin, ex-President Trump and his inner circle targeted election officials in at least 200 apparent acts of public or private outreach, pressure, or condemnation. 200 different acts identified by the House Committee reviewing all of this. They go on to say that that included 68 meetings or attempted phone calls, connected or not connected, text messages aimed at state or local representatives, along with about 125 social media posts by the former president or his aides targeting these same officials out there. Huge amount of documentation about those 200 acts of outreach, pressure, condemnation, all these different meetings and attempts, some successful, not successful, to engage in conversation. All of that predicates for what Jamie Raskin announced publicly at the final hearing of the committee, and also now codified, not only in the executive summary, but also in this omnibus 845-page document about the referrals made by the House Committee to the United States Department of Justice, as Jamie Raskin explained both publicly and in other interviews with the press, indicating that all of these were based upon the recommendations that the committee finds that these kinds of things should be looked at by the United States Department of Justice. As we have said on this broadcast repeatedly, the United States Department of Justice, again, pursuant to the separation of powers, plainly conducting its own independent investigation of all of this, plainly taking a look at all these transcripts now being produced by the committee, because it certainly is looking at the same witnesses, including the Hope Hickses, including the Kellyanne Conways, other people of the prior administration, but going to be making a decision not premised upon what the Congress wants it to do or based upon what Jamie Raskin thinks it should do, but what the evidence should show. That's the assignment given Jack Smith, who, as you know, is the special counsel responsible to the Attorney General for making recommendations, making decisions about what kinds of indictments might be presented to the federal grand juries. That a different proceeding, separate and apart from, but much related factually to these referrals made by the committee to the Department of Justice. So what are those? They're four in nature, and they are set forth in great detail in the report of the committee. The first one is obstruction of official proceedings in violation of 18 U.S.C. Section 1512. This, frankly, is probably the easiest to prove. Goes to the notion that what the president and others did stopped the voting from happening. We saw that in our own eyes. We saw that there was an attempt, and indeed for a while, for many hours, a success in obstructing the process of doing what? Selecting, identifying, and counting those electoral votes properly in front of the Speaker of the House of Representatives and in front of the Vice President, who's serving there as the President of the Senate. That, under Section 1512, from my perspective, the perspective of an awful lot of people out there, probably among the easier charges if the Department of Justice chooses to pursue this. Obstruction, influencing this process. Again, multiple states involved, trying to get these false electors' documents in front of the vice president, in front of the Speaker of the House. Also, this pressure campaign upon the vice president himself, maintaining improperly, unlawfully, inadequately, and without any justification that he has the capacity to overturn what the electoral votes would in fact command, that all of that was an attempt to obstruct the proper governance, the official proceedings of the United States Congress, doing that knowingly, willfully, wrongfully, a fairly clear premise based upon all the evidence in the report, and probably also based upon the things that the Department of Justice is presenting right now to the United States grand juries convened right down the street at the federal courthouse there. A second charge, in addition to that, advanced, recommended, not compelled, but recommended by the House committee, a conspiracy to defraud the United States government in violation of Section 371, again, Title 18. Much related to the first, this attempt to obstruct the certification of the electors by the vice president, by the Speaker of the House of Representatives, done in a deceitful or dishonest means. That's a part of the basic structure of Section 371. A big part of this lying about the election, right? As extending to the population generally, this notion that the election was stolen. That would certainly be a part of this as well. Overt acts in furtherance of that conspiracy to defraud the government of the proper counting of these votes. Certainly many of them, including these outreach attempts to the vice president. A lot of what we haven't talked about yet this morning, but involving a fellow named John Eastman and his attempts likewise to design this policy, this practice, this structure to overturn the results of the election. That a second charge, conspiracy to defraud the United States government, a bit more challenging to present, but not overwhelming based upon the facts that the Department of Justice probably does have. Conspiracy, then, to make false statements, that in violation of 18 U.S.C. Section 1001, also 371 of the United States Federal Code. This is all about the false electors scheme, right? The false electors to present to Congress, to the National Archives coming out of Wisconsin and at least 6 other states, misrepresentations about what the Electoral College votes accurately did in fact say. Material in its nature, plainly attempting to present to the Congress things that are falsely representing that here in Wisconsin, for example, our 10 electoral votes should in fact be cast in favor of Donald Trump, when in fact the president, that time vice president, now the president of our nation, Joe Biden, had won the presidency. Done with knowledge, done with a willful intent, patently false, plainly. Material in nature, the counting of the votes, significant in terms of the making of false statements, also having to do, again, at a central level with this notion of false electors, presenting those to the United States Congress. And finally, the fourth charge, also presented by the committee, presented to the United States Department of Justice, engaging in insurrection, inciting, assisting, or somehow advancing an insurrection in violation of Section 2383 of Title 18 of the United States Code. And this focuses principally upon the ellipse. The things the president and others said, summoning the crowd there, encouraging them to march to the Congress itself to overturn the results of what was going on there, much related to the other charges proposed by the committee. Doesn't has a lot to do with the other charges and this overall plan, but also probably the most difficult, believe it or not, to show. And you might say, gee, how does that come about? We saw the president himself seemingly inciting violence, encouraging this kind of thing. We also know, based upon past Supreme Court cases, including a case called Brandenburg versus Ohio, the Supreme Court interpreting the law, interpreting Section 2383, and the general capacity under the First Amendment of politicians to say things out there that can, in fact, advocate. They talk a lot about the capacity of politicians to advocate, to fight for certain positions and advocate strongly. That, because of Brandenburg, might be a more difficult charge for the Department of Justice to bring, but nonetheless, a part of these overall recommendations, the four of them: obstructing, influencing an official proceeding, conspiracy against the United States to defraud, making false statements, and engaging in insurrection, all of those coming out of this major report. That's the legal side of things coming out of this report to understand, as this report is consumed by not only the Department of Justice, but also by all of us taking a look at it. Again, the Department of Justice under no obligation whatsoever to embrace or pursue any of that, but codifying from the committee's view the kinds of things that a grand jury might in fact indict on. I mentioned already this false electors scheme. We also know, coming out of this major report, the 845 pages or so, this kind of thing. And here's what the report says. The plan on fake electors emerged from a series of legal memoranda written by an outside legal advisor to the Trump campaign. They identify him by name. His name is Kenneth Chesebro, Chesebro. Kenneth Chesebro. He's an attorney who sent a memo to Rudy Giuliani, again, one of the senior advisors to the president. We know him well, about what the committee said was a president of the Senate strategy. And that strategy, the report says, wrongly asserted that the vice president could select which presidential electors to count during this joint session of Congress, articulating there this problem with this plan. We're going to talk more about that and other things having to do with this report right after this break here on Morning Cannolis. Stay with us for that and more.
My bad, Jim. That was 4 minutes.
All right. Very good. We'll continue then with that continuing discussion about this. We'll continue right with that going forward here. So we know, again, that this fake electors plot coming out of this report as it is described, that report, again, this Kenneth Chesebro being a major architect, if you will, of this fake electors plot, a part of an overall larger description of a memorandum authored by John Eastman. We have talked a lot about him in the past. He also appeared along with Rudy Giuliani and others at the Ellipse on January 6th before the assault on the United States Capitol. John Eastman, in this now infamous memorandum, explaining these methods of overturning the popular and the electoral college results of the election of the previous November. That process, that authoring of this memorandum, reaching back into the states, including Wisconsin, attempting to put forth false electors, falsely representing what they, in fact, are all about. Representing, for example, that here in Wisconsin, we had not returned electors supporting the identification of Joe Biden as our next president. All of that, not only a portion of these recommendations made to the United States Department of Justice, but also identifying the players. And that's another major thing that the report does. Chesebro being among them, John Eastman being among them, again, identifying this not only as a state-focused effort, but also identifying wrongly, illegally, unlawfully, the notion that the vice president of the United States has this ability to choose and pick which electors he would most like to embrace for purposes of that, a major portion of this. And so we get then to things like the 14th Amendment as well. Knowing that the principal focus of this report has been and remains on Donald Trump, a major recommendation here about the 14th Amendment. As we know, 14th Amendment establishes that anyone who is engaged in insurrection, previously having taken an oath of office to support and defend the Constitution, anybody who engages in an insurrection or given aid or support to the enemies of the Constitution should be prohibited from holding any office, civil or military, under the United States of America. We know that out of New Mexico, we already have an invocation of that. A state court judge found that a state official in New Mexico should not take his position based upon that particular conviction under a federal violation, but under the Constitution should not take office there. Here in the report now, we've got the committee saying that Donald Trump himself should not hold office because he himself was involved in the insurrection. Among the 11 specific recommendations is that one, that Donald Trump not be permitted to hold any future office. We know he's already announced his candidacy for the presidency, and goes on to say the committee should create, the Congress rather, should create a formal mechanism for evaluating whether individuals who violate the 14th Amendment should be barred from future federal or state office. That having to do with the 14th Amendment. In our final segments, we'll talk more about what the future holds, not only for these referrals, but this report and the other contents of it. Stay with us here on Morning Cannolis. We are back in our final segment here on Morning Cannolis. Some final findings coming out of this major report of the January 6th House Select Committee, and those include evidence also of dereliction of executive duty to act to stop the violence. A huge amount, tremendous amount of very compelling testimony saying this: President Trump did not contact a single national security official during the day, that is January 6th. Not at the Pentagon, not at the Department of Homeland Security, the Department of Justice, the Federal Bureau of Investigation, the Capitol Police Department, or the District of Columbia Mayor's Office. That's the specific language talking about these hours that passed when his own staff, his own family coming to him, asking him to call off the violence, doing nothing, and beyond that, not calling upon any law enforcement likewise to engage in some attempts to stop the violence there. We know that the vice president himself in a secure location, the Speaker of the House of Representatives, Nancy Pelosi, doing just that, as did others, trying to get this under control. Significantly, the testimony of Mark Milley, who's the chair of the Joint Chiefs of Staff, said this, said, "You're the commander-in-chief. You've got an assault going on at the Capitol of the United States of America, and there's nothing, no call, nothing, zero." All of that supporting this finding by the committee that the former president was derelict, not only in failing to act with respect to calling people off, but also failing to involve law enforcement in some major way. Before the break, I talked about Kenneth Chesbro, John Eastman. The committee goes on to describe many other co-conspirators, including Jeffrey Clark, a former major supervisor at the U.S. Department of Justice, who almost became our Attorney General in the waning days of the Trump administration. Chief of Staff Mark Meadows, likewise identified in the committee report as a co-conspirator in many of these actions, along with, yes, Eastman and Chesbro, Rudy Giuliani, again, this senior figure in the Trump administration, all of them identified as supporting lieutenants of the ex-president in this broad scheme to overturn the 2020 election results. Interestingly, a state senator named Doug Mastriano, you may recall his name. He was a candidate for Republican governor, at the time a state senator in Pennsylvania. According to the report, he conferred regularly with Trump about securing letters from other state legislators in Pennsylvania asking Republican federal congressional leaders to reject the Pennsylvania electoral votes. Again, a part of this all-state process to get the electoral process undermined. Couple of additional very significant things that have kind of fallen under the radar when it comes to major news coverage. Turns out there are also a blue team and a green team as a part of this overall effort, executed by the House committee. The blue team is focusing upon law enforcement, and a lot of findings about the extent to which law enforcement prior to January 6th did its job. Says this: in the midst of a flood of threats of potential violence on social media, other avenues of that, law enforcement failed to share and act on those threats and jeopardized the lives of the police officers defending the Capitol and everyone in it. Among the other significant anecdotal support for that notion, there is an account from a Secret Service agent prior to January 6th saying that their plan, this is a direct quote, is literally to kill people. Please, please, the Secret Service agent says, take this tip seriously and investigate further. And again, a finding by the committee that law enforcement not properly prepared, not properly identifying and passing on this major information about what was about to happen. And then a green team, also a part of the committee work, says this: the Trump campaign and the Republican National Committee raised more than $250 million based upon the president's false claims of a stolen election. Says this in particular: President Trump's claims were treated as true and blasted to millions of people with little to no scrutiny by those tasked with ensuring the accuracy of them. A green team report about the amount of money that was also made by the Trump campaign, by the RNC, as a result of this perpetuation of this false lie. And significantly, we talked about a lot of lawyers during the course of this. We know that the committee report also recommends that courts and bar disciplinary bodies responsible for overseeing the legal profession generally in states across the country, including the District of Columbia, should continue to evaluate the conduct of attorneys, yes, like Rudy Giuliani, like Sidney Powell and others who are described in this report. And again, a major advocacy not only for the bar committees, but also for courts to take a look at what those attorneys did in advancing this false lie. And finally, in terms of significant things that come out of this, a recommendation about something that did in fact happen. Major amendments to the Electoral Count Act of 1887. Recommendations made on Thursday, passed by the United States Congress on Friday. The amendments, again, incorporated in the report, now a part of our law. The good thing coming out of this all establishing a single conclusive process for recognizing the official slates of electors. Again, addressing this false elector process that Eastman and others had designed, that we've talked about, that the report also describes in great detail. How does it go about doing that? It says it identifies the governors as the people who are supposed to be certifying officially a specific elected officer, the governor or somebody else identified by the legislature, to be the one person who says that this indeed is the proper and accurate and non-false, the real state of electors presented to the National Archives and to the Congress. An expedited review between the time of the election and the counting of those electoral votes for genuine contests, real contests, if in fact those exist, presumably in the federal courts. That also established by these amendments to the Electoral Count Act, and modernizing the counting rules. Most significantly among those, establishing clearly that the Eastman concept, that the vice president has the role as the Senate leader to make decisions about electoral votes and counts, that he can in fact choose among them, that's simply wrong. Establishing clearly that the vice president's role in this process is purely ministerial, and raises the threshold for contesting electoral votes to 1/5 of the sworn members of the House of Representatives, basically protecting, if you will, the process, recognizing that the president of the Senate, the vice president, is simply there to open up the envelopes and count them, does not have any substantive role in choosing which votes are to be identified and which votes are not. Again, the good news coming out of one of the last acts of this Congress, not only incorporating those proposed amendments into the Electoral Count Act, passed by the Senate in a bipartisan House, a bipartisan Senate, going on to the president as a part of this omnibus budget bill that was passed by the Congress and again signed by the president. And so now we do have electoral count changes that happen. All of that a part of the results of this overall review by the House committee. Thank you so very much for joining me this morning, as in every morning, as we talk about these important issues. We'll be back again next Saturday to talk about more news, doing more of our summary of 2022, and looking forward to 2023. Again, thanking you for your time together this morning. As always, here on Morning Cannolis, our review of law, justice, and the aspiration for justice in America. Have a good new year, everybody. We'll see you again next week.